Imagine waking up one morning, pulling out your green card, and realizing USCIS could deny your renewal. Even if you've lived in the United States for decades, paid your taxes, and never broken the law. Sounds impossible, right? Well, in 2025, that nightmare is becoming a reality for thousands of immigrants. Green card renewal denials in 2025. Green card renewals are no longer the straightforward process they used to be. In the past, permanent residents could file Form 190, wait a few months, and almost automatically receive their updated green card. Today, that picture has changed dramatically. USCIS is now denying renewal applications in record numbers, creating confusion, legal contradictions, and hardships for families. This is not speculation or rumor. It is a very real shift that every immigrant must pay attention to in 2025. If you hold a green card, what we are about to discuss could directly impact your future in the United States. So, the first is voluntary abandonment, which happens when someone signs Form Y-407 and formally gives up permanent residency. The second is involuntary removal, which, requires an immigration judge to review the case and issue a removal order after due process in court. Outside of those two scenarios, a person's lawful permanent resident status actually remains intact. For decades, USCIS respected this legal principle. Renewal applications on Form 190 were processed with minimal scrutiny, and unless fraud or serious issues were detected, approvals were honestly pretty routine. A green card expiring did not mean someone lost their status. It was simply a matter of updating the physical card. But beginning in 2025, that basic understanding has started to erode. So here's the case that really raised alarm. There was this one case that became a turning point for immigration attorneys and immigrant families alike. A permanent resident had to spend about 1 year abroad, because of a family emergency. When he came back to the United States, border officers questioned him, but they let him re-enter without placing him in removal proceedings. He just continued his life in America, assuming, understandably, that his residency was secure. Later on, he went ahead and applied for naturalization by filing Form N-400. That application was denied since his year-long absence disrupted his continuous residence requirement. Honestly, that's a reasonable and well-established rule. But here's where things took a turn. The real shock came when his green card expired and he applied for renewal using Form 190. USCIS denied it. They claimed that his 1-year absence meant he had abandoned his residency even though he had never signed abandonment papers and no immigration judge had ordered removal. This decision was honestly more than just unfair. It directly contradicted the law. So, without a judge's order or even a voluntary form, USCIS really isn't supposed to declare abandonment. Yet, in this case, they went ahead and did it unilaterally, setting kind of a troubling precedent. This denial, it really highlights the contradictions at play within USCIS. On one hand, the agency claimed the applicant abandoned his residency and refused to renew his green card. But on the other hand, USCIS actually let him file a new N-400 for naturalization, which, automatically extended his green card by up to 24 months. Basically, the same agency that declared his status abandoned also granted him lawful documentation confirming his residency. These kinds of contradictions honestly make the system unreliable and pretty confusing. For decades, attorneys advised their clients to re-enter the United States after long travel and then file for green card renewal. This was a safe strategy because USCIS typically approved the application. But in 2025, things are different. USCIS is subjecting I-90 renewals to deeper background checks, closer examination of travel histories, and yes, stricter interpretations of what constitutes abandonment. Cases that once passed without issue are now being flagged. Denials are being issued based not on clear law, but on discretionary interpretations of extended absences. This creates enormous uncertainty. A permanent resident with decades of life in the United States could suddenly be left without valid documentation simply because USCIS decided their travel history raises questions. One of the most important warnings for immigrants today, honestly, concerns international travel. In the past, some green card holders felt comfortable spending long periods abroad, confident they could return as long as they didn't formally give up their status. That era is over. Spending more than 1 year continuously outside the United States is now a major red flag. Border officers may pressure travelers to sign Form 1407 at the airport, which would mean voluntarily abandoning residency. Many immigrants do not realize the permanent consequences of signing that paper. Even if you refuse, you may still face consequences. Officers may allow you entry, but issue a notice to appear in immigration court starting removal proceedings. In rare but real cases, detention can also occur, especially if the traveler has a criminal record or appears on a security list. For green card holders, the message is clear. Long absences are now extremely risky. The most confusing part of all this is the contradiction between naturalization applications and green card renewals. USCIS may deny a renewal on the grounds of abandonment, but still accept a naturalization application, which automatically extends the expired green card. How can a person be told they abandoned their status while also being given an extension of that same status through another filing? This contradiction exposes the inconsistency in how USCIS is interpreting the law. So it leaves immigrants in this legal gray zone where, their residency is technically valid, but their documentation is, denied. These denials are not just legal puzzles. Honestly, they're creating very real consequences for immigrant families. Without a valid green card, many residents face barriers in everyday life. Renewing a driver's license becomes impossible in many states, and proving work authorization to employers turns into a battle. Travel abroad becomes nearly impossible since airlines often refuse boarding without a valid green card, even if an extension exists through naturalization paperwork. The effects ripple into family life, too. A parent without a license may struggle to take children to school or commute to work. Financial stability is put at risk. The stress affects spouses and children alike. What looks on the surface like a paperwork issue actually cuts into daily dignity, stability, and security. So why is USCIS denying renewals in ways that contradict the law? Many immigration attorneys believe this is the result of political pressure. The government wants to show a tougher stance on residency compliance and border control. So, by treating long absences as abandonment, USCIS is really signaling stricter enforcement. But, this practice doesn't actually rest on any new legislation. Immigration law hasn't been rewritten. Instead, what's happening here is an interpretation shift inside the agency. That means the policy is legally vulnerable and honestly could eventually be overturned by the courts. Litigation is likely, but until rulings are made, immigrants are, stuck right in the middle. So what do green card holders need to do now? Well, it's important to keep detailed records of your ties to the United States. Things like tax returns, property leases, employment documents, and family connections, all of these can help prove that your residency is still intact. And just as a reminder, even if USCIS denies your green card renewal, that does not automatically mean you've lost your status. The truth is, only a signed abandonment form or a judge's order can actually end your permanent residency. The contradictions in the immigration system in 2025 are honestly leaving immigrants trapped between conflicting interpretations of the law. Green card renewals are being denied, while naturalization is, oddly enough, encouraged. Documentation is withheld, but residency technically remains intact. Until the courts step in, this confusion is just going to continue. Thank you for watching, and we'll see you in the next video.